Last week, the Ninth Circuit Court ruled that Americans only have a right to carry guns at home or at their own businesses, but not in public. They claim to have examined 700 years of legal history. The court ruled 7-4 and noted there is no right to carry arms openly in public, nor is there any such right within the scope of the Second Amendment. While most conservatives would have a visceral reaction to this statement, there's much more to it than meets the eye. We'll look at this in this episode of Analysis Behind the News, where we provide the perspective and the plan to help restore American liberty and independence. The Ninth Circuit Court of Appeals was hearing a case from Hawaii of a gentleman who had been denied a carry license, which would have allowed him to carry a weapon outside of his home. The New American reported that in 2018, a panel from the same court sided with the gentleman that carrying a gun in public is a constitutional right. However, a majority of the full panel reversed that decision last week, suggesting the Second Amendment merely applies to the defense of hearth and home. According to the New American, the verdict also noted the Second Amendment did not contradict the fundamental principle that the government assumes primary responsibility for defending persons who enter our public spaces, Judge J. Bybee, a George W. Bush appointee, wrote for the majority. The states do not violate the Second Amendment by asserting their long-standing English and American rights to prohibit certain weapons from entering those public spaces as means of providing domestic tranquility and forestalling domestic violence. These are fascinating statements that are chock full of inaccuracies. First of all, where in our founding documents does it establish that a fundamental principle was created where government assumes primary responsibility for defending persons who enter public spaces? None exist. Courts have long ruled that the police do not have a responsibility to protect you. This has helped give rise to such statements as, "I carry a gun because a police officer is too heavy," and "when seconds count, the police are minutes away." Now, this is not meant to disparage those in law enforcement, but in reality, communities cannot afford to have police on every street corner, in every public space, or behind every tree in rural areas. If we did, we'd live in a police state. Police states are antithetical to free societies. Second, providing for domestic tranquility and forestalling domestic violence assumes the violence comes from the people. Well, what happens when the tranquility is disrupted by violence from one's own government? The Declaration of Independence lists this as one of the reasons the Founding Fathers broke away from the British Crown. The King forced the colonists to accept into their homes British soldiers and legally protected these soldiers from any punishment that may have come from their actions against the people, including murder. As the saying goes, an armed person is a citizen and an unarmed one is a subject. For Judge Bybee to suggest that states do not violate the Second Amendment through regulation and weapon prohibition is also wrong on its face. The preamble to the Bill of Rights tells us why the rights, including the Second Amendment, was added to the Constitution. It reads, "The conventions of a number of the states, having at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government, will best ensure the beneficent ends of its institution." So think about that for a minute. The Second Amendment was added to help give the public confidence in the government. They had just fought a war for independence, which had started when British soldiers were sent in to confiscate guns and ammunition. Does the judge actually think that while the federal government was not allowed to infringe on the right of the people to keep and bear arms, the states could? Even though the Second Amendment was written to ensure the security of a free state? Some folks make the argument that the militia referred to in the Second Amendment is actually the National Guard, but fail to note that militias back in the founding era included all who could use a gun. During the convention to ratify the Constitution in Virginia, Founding Father George Mason asked and answered the question regarding the militia. I ask, who are the militia? They consist now of the whole people except a few public officers. In 1789, the House of Representatives was discussing the Second Amendment, which would be ratified as part of the Bill of Rights in 1791. Representative Elbridge Gerry from Massachusetts said, "What, sir, is the use of a militia? It is to prevent the establishment of a standing army, the bane of liberty." Now it must be evident that under this provision, together with their other powers, Congress could take such measures with respect to a militia as to make a standing army necessary. Whenever governments mean to invade the rights and liberties of the people, they always attempt to destroy the militia in order to raise an army upon their ruins. This was actually done by Great Britain at the commencement of the late Revolution. They used every means in their power to prevent the establishment of an effective militia to the eastward. The Assembly of Massachusetts, seeing the rapid progress that administration were making to divest them of their inherent privileges, endeavored to counteract them by the organization of the militia, but they were always defeated by the influence of the crown. The founders did not want to see the people impeded from access to arms, nor did they want to see the U.S. have a standing army, which could be used against the people. Even currently, the recent decision to extend the stay of National Guard troops stationed at Capitol Hill is calling into question the role of the Guard. As retired U.S. Air Force Major General Donald McGregor wrote in an online article at thenewamerican.com, yesterday, the co-opting of a state's sovereign militia by the federal government to be used as an unlawful domestic police force distorts the vertical balance of power between state and federal governments, an essential diffusion of power. Further, it abdicates the states' responsibility granted by the Constitution to protect the liberties and freedoms of their citizens. What our founding fathers feared most was a president or military chief indiscriminately coalescing military forces to police its citizens, just one of history's tragic paths to tyranny and oppression. Adding to this, President Biden has said he will use executive orders to push additional gun control, while both houses of Congress attempt to coalesce support to pass draconian gun control bills, including a ban on several semi-auto sporting rifles, higher capacity rifle and pistol magazines, universal background checks, and buyback programs. Now is the time for common sense Republicans and Democrats to stand strong against such unconstitutional measures. History has proven that long-term effects of gun control allows a central government to control the people. However, the American constitutional republic is supposed to protect your rights, not to take them away. Your help is needed in stopping this. Help by shoring up opposition to this in the U.S. Senate, and contact your state legislators to educate them on using nullification to stop any of these unconstitutional measures if they do pass. State legislators, county sheriffs, and others in authority need to know they can nullify these efforts. Use our legislative alerts to contact your senators about stopping the proposed gun control measures, and then contact your state legislators about supporting nullification. Nullification is a tool that can be used immediately. In many instances, it was the only tool to lift COVID-19 lockdowns. Links are in the video description, or head over to jbs.org under Act Now for state and federal alerts. Who do you know that cares about freedom and independence? Because folks, it's time to act. The very survival of our republic depends on it. I'm Bill Hahn for the John Birch Society, and until next time, stay informed, stay active, and be bold, patriots.